I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other Freedom of Information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to our instructor.
Hey everybody, my name is Emily Sweeney. I'm with the Boston Globe and the New England First Amendment Coalition. And I want to thank you all for joining us for this webinar, which is part of our ongoing series on public records laws. With us is Leah Ernst. Leah serves on the board of NEFAC with me, and she is the legal director at the ACLU of Vermont, where she litigates civil liberties, civil rights, and open government cases. So thank you so much, Leah, for joining us.
Great. Yeah, I'm very happy to be here tonight. So the very first thing I would say about what you should do if your public records request is denied is do not take an initial denial as the end of the matter. Many agencies have a knee-jerk denial reaction. Deny first, see if it's justified later, and will relent with just a little bit of pushback. So that's if you take away nothing from tonight besides that, I will feel like I've at least advanced the ball somewhat. So just first a little bit on the mechanics. Under the Vermont Public Records Act, an appeal to the head of the agency is required before you could go to court. And that's true even if it's the same person who initially denied your request, which probably seems futile and foolish, but nevertheless it is required. You have no set time limit by which you have to file your appeal with the head of the agency, but there arguably, I think it's a weak argument, but arguably is a 30-day deadline to file suit in court after denial of the appeal. So time your appeal accordingly. If you're thinking you might want to go to court, be sure you're ready to file within 30 days if you think you're ultimately going to have to litigate. Again, I think the argument is wrong, but why give defendants a tool to use against you? And even if you prevail against that argument, like why force your lawyers to do unnecessary briefing? So that's my first tip, just on sort of the pragmatics of it. You can treat a failure to timely respond as a denial and immediately appeal, and you can treat a failure to timely respond to an appeal as the final denial, and then you can go right to court. So if they're not meeting the deadlines, you can advance your argument to the next stage. Personally, we at the ACLU of Vermont tend to be a little bit lenient on the timelines in the PRA, in part because they're short by comparison to the Federal Freedom of Information Act and other state Public Records Act. But also because the Supreme Court of Vermont has held that those timelines are aspirational but not enforceable. And so, like I said, we tend to be a bit lenient on the timelines, but we are not lenient on the substance. That's where we feel it's really important to hold the line. So with that sort of as a backdrop, I'll sort of dig into some specific strategies you might employ if your initial request is denied. The first thing we always do is recommend that you ask for an index of any withheld documents, and this is required under the law, specifically 1 VSA 318b2. It requires that an agency withholding documents describe the documents withheld and set forth the exemption they're claiming and the factual basis for justifying the application of that exemption to that claim. And they're required to do this under law even if you don't ask, but experience shows that they routinely don't produce this index. So if your initial response is just a flat denial, the first thing to do is ask for a 318b2 index. Or it's also called a certification and sometimes referred to as a Vaughan index, although there's some slippage there that I can get into in a moment. But sometimes just making them justify their withholdings makes them realize either that they aren't in fact justified, or if they do produce this index, it gives you information about what records exist and a means to challenge certain withholdings as not fitting within the exemption they claim. So that's going to be your first step, is requesting this index. We've been hearing, and I've had this happen in one of my cases, this sort of new argument being trotted out that this index or certification is not required when the agency is asserting what is called a categorical exemption. I think this is wrong on many bases. I mentioned before, there's some slippage between Vaughan Index and this certification under 318B2. And so agencies are saying we don't have to produce this by citing to a Supreme Court precedent that said in certain circumstances, a Vaughan Index may not be required, where an agency is asserting a categorical exemption. And I think this is doubly mistaken. First, although these terms are sometimes used interchangeably, they are in fact different, and the obligation to produce them springs from a different source. So a Vaughan Index comes from a US Supreme Court case by the name of Vaughan. It's a judicially created requirement that the agency justify its withholdings to the court. It's for the court to review the index and possibly even the documents and determine whether the withholdings are appropriate. The certification required under our Public Records Act is required by statute when the initial response is anything other than producing all the documents without redaction. So that's required in every case in which an agency withholds documents, regardless of the exemption claimed or regardless of the documents sought. So that's the first reason I think that's a bad argument. And the second is that the so-called categorical exception that the court dealt with in the case where it held, sometimes you don't have to produce a Vaughan Index. It dealt with the former exemption for all records relating to the detection and investigation of crime. And the parties in that case agreed they were all categorically exempt. But that has been completely reversed in the law. The legislature has updated the law so that now law enforcement records, they were wholly exempt from the PRA. Now they're presumptively public and are only exempt under certain specified circumstances. So the law itself has changed since then. But at its essence, a categorical exemption is one where, in order to determine whether the exemption is proper, you don't even have to look at what the record contains. It's just the type of record. It might be, a certain investigative file or a specific form or whatever that the law makes exempt based on the type of record, not the information it contains, not its content. And so, there in that case, because these were concededly records dealing with the investigation and detection of crime, there was no need to look at the content on a document by document basis. So there was no purpose of producing a Vaughan Index. There was no work for the court to do in determining whether the exemption was proper. But this is just not true of other exemptions. You need to do more than just know what the type of document is. You need to look at the document. For example, it's been cited often, I don't need to produce a 318 index because these records are relevant to litigation to which the agency is a party. You'll come up across that exemption frequently. But you don't know if they're relevant without knowing what's in the documents. You can't just, decree that all documents, all communications between this person and that person are relevant to litigation without knowing what's in the communication. So I think this is a bad argument. I think it's unfounded. But nevertheless, we are seeing some agencies try to evade the obligation to produce this index under this argument. And so should you come across this argument, I would love to hear from you. I think it's what we see in Vermont practice is an argument starts gaining traction among agencies, and then you hear it trotted out time and time again by different agencies. And I think that's dangerous. And so I think this is something worth really pushing back on. Unfortunately, we did just get an opinion in a case today where we were litigating this question. But in that instance, the court held we didn't have a right to a Vaughan in the specific context of the case, which was a little procedurally proper. So we didn't have to the VAWN, which is the court-created remedy, and that the state had already satisfied its obligation under 318b2 by producing what we believe is a completely inadequate index. So that's frustrating, but I think, you know, the fight will go on. And so if you are coming up against this particular argument, I'd love to hear from you. A second reason for denial that we see quite frequently, that is wholly without merit, is an agency will say the records in question are protected by a confidentiality agreement that we put in a contract with, you know, the other party to these records. And the Supreme Court has been clear that it's explicitly and expressly rejected the notion that an agency can contract its way out of compliance with the Public Records Act. So if you get that argument, you can kick that one throw that one right out the window. It's no good. It's been rejected. Nevertheless, people still try to assert it from time to time. Sometimes if you get if what you're looking for is a certain form, say you're looking for a form that officers submit in support of probable cause, or just any sort of form, or a form submitted to the Agency of Health and Human Services regarding care in long-term care facilities or whatever, just any sort of form. If they're withholding that form in full, saying we cannot produce this form to you, like the filled out forms, what we recommend is that you just request a blank version of the form. And what this does for you is you can see what fields are captured on the form, and then walk through that form field by field and require the agency to justify why each field on this form fits within an exemption. They'll often back down when forced to justify on that sort of granular basis, because as you're probably aware, the Public Records Act is clear that if a document is subject to an exemption in part, the agency is required to produce the document and just redact the parts that are subject to a valid exemption. They can't withhold a record in full because some of its information is exempt. And so with this form example, it's hard to imagine any form on which every single field would be subject to an exemption. So, like I said, if you get a denial, put the agency through its paces and require it to justify in this case, on a very granular level, why each field is exempt. Another strategy that we've employed is if both entities to a particular communication are within the Public Records Act or the FOIA, the federal, not FOIA, or another state's Public Records Act, submit a request to both sides of the communication, right? If you're looking for communications between the federal government and a state agency, submit a FOIA to the federal government, submit a PRA request to the state agency, and see if they produce the same things, right? So oftentimes you'll get different responses from each, and you'll be able to tell whether one is improperly withholding records from you. Another response that we see a whole lot is, yeah, we could produce these records for you, but first you have to pay us some exorbitant amount of money. The agency is allowed to charge for staff time associated with complying with a request for a copy of public records. Under Supreme Court precedent that we litigated, actually, it's clear that the Public Records Act allows that charge if you're requesting a copy that you can take with you. It's your own copy of the record, but not if you're merely requesting to inspect a record, meaning go into the agency, use their public access terminal, or hold in your hands the actual paper records and look through them there. The agency is not permitted to charge you in that case. Oftentimes, if you request to inspect rather than copy, an agency will just send you the records because they don't want you sitting in their lobby going through these records or whatever the case may be. So it's always useful to request to inspect the records if the cost of getting copies is prohibitive. And that can help you narrow your request for copies if you ultimately want some of those records in copy that you can take with you. You'll know specifically which ones to request, and the charge will be significantly lower. let's say you're requesting records from a private entity that is working under contract with the government, and they say, you know what, we're private, we're not a public agency, we're not subject to the Public Records Act. That may be true, it may not be true. Under a recent Supreme Court case called Human Rights Defense Center v. Correct Care Solutions, the Supreme Court held that the private entity providing comprehensive medical services within the Department of Corrections facilities throughout the state was a public agency within the terms of the Public Records Act. Even though it was a private entity, like no one questioned or doubted that. But because of the circumstances in which it was providing these comprehensive services that were constitutionally and statutorily obligated as a state to provide, the court held that this private entity was an instrumentality of the state within the meaning of the definition of public agency within the Public Records Act. And it was therefore subject to the Public Records Act to the extent the records in question related to its performance of this governmental function. So I think, that's a very recent case. I think it'll be interesting to see sort of how that is applied to other types of entities that are maybe less wholly entangled with the government in providing a mandatory service of providing medical care to those in its custody. But I think there's room to run there and figure out sort of the full contours of that decision. And then the last thing I'll talk about is challenging some of the specific exemptions that agencies most often, in my experience anyway, most often invoke. And the first thing to know about exemptions is that for the most part, exemptions permit but do not require an agency to withhold records. There are a few exceptions to that for exemptions that implement a legal obligation not to share information like HIPAA, like FERPA as it relates to student records. But otherwise, there's generally not a legal requirement to claim an exemption, even if that exemption arguably applies. So if an agency suggests that it can't give you records rather than it won't give you records, you can correct them on this front and see if they're willing to relent. But looking at, again, this is, at least in my experience, some of the most common exemptions and how to push back on them. The first one is the exemption for personal records. And the first thing to recognize with that is that it's about personal records, not personnel records. Agencies routinely mess that up and say, well, this record it's placed in someone's personnel file, so it's exempt, it's a personal record. And that's flatly false, but a common misapprehension among agencies. The Supreme Court has looked at that exemption and said, wow, like on its face, that is an extremely broad exemption. Every record that, for example, is a communication between two people could arguably be a personal record. I'm having a conversation with someone, that's my personal record. And so it read into this exemption a sort of balancing test. And it says that we'll construe the term personal documents in a limited sense to apply only when the privacy interest of the individuals involved. And it further read that to mean only documents that reveal intimate details of the person's life, including any information that might subject the person to embarrassment, harassment, disgrace, or loss of employment or friends. So the first question to ask is this a personal record within that meaning? And even if it is, that doesn't necessarily mean it's exempt. In a later Supreme Court case, the court said, okay, so the first question is, does it fit this? Does it reveal intimate information? And second, even if it does, you still have to balance the public interest in that record against that privacy interest. And so if there's an extreme public interest in this conceitedly very private record, it still must be produced. So the one example of where this balance was struck was in a case involving police using agency computers to view pornography during the workday. Now, obviously, the records reflecting that would subject the officers in question to embarrassment and the other interests sought to be protected by the privacy protection. But nevertheless, our law enforcement using taxpayer dollars and taxpayer time to view pornography at work is in the public interest to know, and the court held that those records must be released under this sort of balancing analysis. The second, which I mentioned briefly before, is the records dealing with the investigation detection of crime. As I mentioned, they were presumptively exempt except in certain narrow cases before, but that flipped on its head in 2013, and now they are presumptively not exempt with certain enumerated exemptions. So when I first started doing this work, agencies routinely were citing the old standard and saying you can't have any law enforcement records because they, are categorically exempt. And so we had to do a lot of educating over the years about, how the law had changed. But I don't see that as much anymore. But still, just something to be aware of if you see someone citing the old language to justify withholding records. So in this exemption, the threshold question is, does it deal with the detection and investigation of a crime? Oftentimes the answer to that is no. There must be concrete, actual investigation afoot, not just like general policies, not just looking at not just looking at things that aren't a specific crime that is under investigation. And then the second step is, okay, so if they are, as a threshold matter, dealing with the detection and investigation of a crime, what is the triggering condition that allows you to withhold? And what we see most often is it would interfere with an ongoing enforcement proceeding. And so under that, you have to ask, is there a concrete, actual ongoing enforcement proceeding? If not, you don't get to claim that exemption. And agencies are required to show not only that there is this ongoing enforcement proceeding, but also how release of these records would harm that enforcement proceeding, and must do so on a document by document or category of documents basis, not just all the records dealing with our investigation into such and such a crime are exempt because to release them could interfere with the law enforcement proceeding. No, they must justify on a granular level why the interest sought to be protected by this exemption would not be served. So I see we're at 23 minutes now. So the last thing I would just say before opening to any questions you may have, if you do, is quickly to talk about going to court after your appeal has been denied. One thing of note is that the Public Records Act specifically directs courts to prioritize Public Records Act cases. It says that these proceedings under the PRA take precedence on the docket over all cases and shall be assigned for hearing or trial or for argument at the earliest practicable date and expedited in every way. And this is just another example of how the PRA really seeks to protect our interest in holding our government to account and seeks to protect the transparency interest that that we have by right as Vermonters. And so, this is just yet another recognition of the value of government transparency and accountability over competing interests. These cases typically proceed in a simpler fashion than other civil litigation. There's often no discovery because the question is a purely legal one about the validity of an exemption. Often, you file the complaint, the defendant will answer, and then often you just proceed directly to motions for summary judgment, which in most civil litigation that I am involved in at the ACLU doesn't happen until quite a ways down the line in a case. So they are typically quicker cases to be resolved. And importantly, the prevailing plaintiff in a Public Records Act case shall be shall receive, not just may, but shall receive costs and reasonable attorney's fees. So this was an amendment that happened in 2011, where beforehand, the court had discretion to grant attorney fees to a prevailing plaintiff in a public records case, but now it's shall receive. And so that's, I think, an important provision, because in the May days, courts were very reluctant to grant these fees. And so I think that's an important and it's an important improvement to the PRA, and again reflects how the legislature has really sought to ensure that the PRA serves its purpose of guaranteeing that the government answers to us and not the other way around.
Thanks, everybody, for participating and tuning in.
Be well, everyone. Take care.